Hello and welcome to this guide on debt relief orders. This guide will help you if you're struggling with debt, and it applies only to England and Wales. What are debt relief orders? In 2007, in response to the growing calls for reform in this area, the government introduced a new alternative to low value bankruptcies called debt relief orders, or DROs. DROs are a debt remedy available to help those who can't pay their debts and have little or no spare income or assets. You must not be a homeowner. Orders last for 1 year usually, and after 1 year, the debts are written off. Can I have a debt relief order? You can if you live in England and Wales, you haven't had a DRO in the last 6 years, or are an undischarged bankrupt, you owe less than £20,000, you don't own your own home, you don't own goods worth more than £1,000, excluding work tools and domestic goods, unless they can be sold and replaced with reasonable replacements. That would cover where you had work tools that were really expensive and they could be sold or subject to reasonable replacements. And you don't own a car worth more than £1,000. You must not have less than £50 a month spare income, and spouses' contributions are taken into account in this. You haven't given anything of value away or sold anything for less than its true value in the last 2 years, and you haven't paid anyone in preference to your creditors in the last 2 years. So what debts can I include in a debt relief order? Well, you can include credit cards, bank overdrafts and unsecured bank loans, rent arrears, utility bills, council tax and income tax, overpayments of benefits, hire purchase and conditional sale agreements, though if you have goods worth more than £1,000, they may need to be returned, bills for services like electricians, vets, etc., debts to friends and family, business debts and county court judgments, except damages for negligence. What can't I include in a DRO? You can't include student loans, fines, payments under sums due under confiscation orders. You can't include damages for negligences, as I've explained it, and you can't include social fund debts if after 2013. But note that the social fund itself is no longer with us. So I think I qualify. What now? Well, your application will have to be made through an approved intermediary. This is usually a money advisor. The money advisor will help you make the application. They will check to see if you're likely to be eligible and qualify, and then they will send this electronically to the insolvency service. A list of organisations who can help you with this are at the end. The cost is £90 and this is non-refundable. This can be paid in instalments via PayPoint cards, but must be paid in full before the application can be processed. The official receiver will consider your application and may check that the information you give was correct using credit reference agencies to check that you don't go over the £20,000 debt mark, and the insolvency registers to check that you aren't subject to any restrictions or are an undischarged bankrupt. So it's very important that you give correct information and are honest. So you may be wondering, what do you do while you have a debt relief order in place? Well, you must cooperate with the official receiver. You must tell the official receiver if your income increases so that you have got more than £50 per month, or that you acquire goods or capital of more than £1,000 during the 1 year moratorium period, which is the 1 year in which your debts are on hold. You must inform him if you realise there's any mistakes in the application, or if you've missed anything out that would have taken you outside of the eligibility rules. You must tell the official receiver if you missed any debts. If more than £20,000, the order will be revoked. If you've missed a debt off, you had £19,000, you find a debt for £2,000. You tell them those, then you would not have then been entitled to a debt relief order, and the order will be revoked. However, the law specifically states debts cannot be added. So if you've got £10,000 worth of debt amongst 30 different people or companies, and you've missed one for 5,000, that would have took you up to 15,000. That can't be added, although it would not have taken you outside of the eligibility rules, but they cannot be added. So you must make sure when you apply for a debt relief order, because this was a common problem that I used to see, debts can't be added. Failure to do this may be a criminal offence, and you could end up with a debt relief restrictions undertaking or debt relief restrictions order, and or your order being revoked. And I'll tell you more about debt relief restrictions in a little bit. What can't you do? Now, these are debt relief restrictions. So you can't take out credit for more than £500 without informing the lender of the debt relief order. You can't take out more credit pardon me, or engage in business in a different name from the name in which the order was made without giving that name. So if you try and engage in some kind of business with someone and you give a different name to the name in which the order was made, then you will be committing an offence. Getting involved with a limited company without getting permission from the court, or acting as a director of a company without permission of the court, is also a big no-no. You can ask a court for permission to get involved with a limited company or to act as a director of one, but you will need to apply to the nearest bankruptcy court at your bankruptcy hearing centre. You will be told exactly what you can and can't do. If so, you can find your nearest bankruptcy court at the link here. What can my creditors do? Well, they can object to being included if they can provide evidence on a prescribed ground that you should not have qualified in the first place. They must write to the official receiver within 28 days. No one can make you pay your debts whilst the order is in force. No action can be taken to enforce any of the debts in the order, for example by bringing a county court claim or trying to enforce a county court judgment. Are there any downsides, and what can go wrong? Well, your credit file will reflect that you've had a debt relief order for 6 years. You could end up with lengthy restrictions known as debt relief restrictions if your debts were caused by gambling or dishonesty, or by failing to cooperate with the official receiver whilst under the legal duty within the DRO itself. Your name will also be added to the insolvency register. This is a public database and can be searched, and I've provided a link here if anyone wants to look at that. And or the debt relief restrictions register, which is a separate register, and I've provided a link here if anyone wants to look at that. And I would suggest people have a look at this because it really is interesting to see, to look. If you look at this, the restrictions register, you will often see 15-year restrictions orders for really huge gambling debts, or people who have become insolvent or subject to restrictions because they've done something dishonest and been sued for it perhaps. But there's a wide range of financial wrongdoing on that register, and they see gambling as a reason to impose really lengthy restrictions, which seems a little bit questionable to me, but that's the state of play at the moment. And I would really recommend everyone looks at the restrictions register just to get an understanding of what it's all about. If you are at risk of violence, you can apply to court to have your address or other details excluded from the public register. The only other details that can be removed would be other identifying information, maybe previous addresses, or perhaps even your name might be omitted. But this must be done and applied for prior to the application for the debt relief order. Your debt advisor should be able to help you make such an application. If you are experiencing domestic abuse, you can get help by contacting Refuge, and I've provided a link here. So if you got credit knowing you could not repay it or have large gambling debts, the official receiver may consider a debt relief restrictions order, or a DRRO. You could be asked to enter into an undertaking called a debt relief restrictions undertaking. Now that's if you refuse to enter into a DRRU, then the DRRO will be imposed by a court, and that is the difference. The undertaking is usually less lengthy as an order would be. So if that was to happen, it would be far more beneficial to enter into a DRRU than have an order imposed by the court because you refuse to enter into that agreement. Both a DRRO and DRRU are between 2 to 15 years in length, with the DRR being likely to be shorter, which will mean that the debt relief order restrictions could be in place for a very long time. That could affect your ability to get bank accounts, to get credit in the future, to act as a director without permission of the court. There are quite a few financial and economic restrictions that come along with that. Knowingly being dishonest in your application or not informing the official receiver of any changes may result in the details of any wrongdoing being made public on the debt relief restrictions and bankruptcy restrictions register. That is available here, and I suggest that people have a look at that to see the range of DRROs and DRRUs that have been imposed for things like gambling debts. And if you do have a gambling problem, there is a link here to Gamblers Anonymous for help with that. However, people should be aware that if there has been wrongdoing which has caused the insolvency, details of this may be published if you are asked to enter into a DRRU or a DRRO. So, a word of caution: there are DRO offences. These can incur fines and possibly even jail. So the first debt relief offence is false representation or withholding information. So if you told the official receiver you don't own any property, or you don't tell him about your boat in France, and he finds out, that would be a debt relief order offence. Also, concealing or falsifying documents. So if he asks you for your wage slips or bank statements, and the bank statements show you've got assets which you've hidden or something similar, to say you've lost them, or if you would even go as far as falsifying documents, that would be an offence, and that sounds quite serious. Fraudulent disposal of property. So, and that can include, there's an interesting offence here called fraudulent dealing with property you got on credit. Now, how many people have sold property that they've got on credit? I know, I can think of lots of instances where people have sold property they've got on credit. But if you were to go bankrupt after you've done that, or sorry, if you were to get a debt relief order after you've done that, and that was discovered, that would be an offence, and you can get fined and even go to prison for that now. Getting more credit or engaging in business in a different name. Now, we just discussed that earlier. If you were to engage in business in a different name than the one which you made the order in, and you didn't give that name to the person you were doing business with, that's an offence. And again, getting more credit I think it's more than £500 without giving the name is also an offence. Okay, so what should you do next? You must apply through a specialist debt relief order advisor. This is a money advisor who's been trained to check the forms and advise you on DROs. They are referred to as approved intermediaries. Most Citizens Advice Bureau will have a DRO advisor. You can contact CAB at the link provided here, or you can find a money advisor here or here on the .gov website, and I've provided the links there. What happens after the application is made? So you paid your £90, you've been into CAB, they've filed your application off to the receiver. What happens next? Well, the law says the official receiver must be satisfied from all of the information that you qualify and are in law unable to pay your debts. He will either make or refuse the order, or may ask for further information before making a decision, and he must cooperate. You won't have to pay anything towards the debt for 1 year usually. This is called the moratorium period. After 1 year, the debts will be written off. If anything happens within the year that takes you outside of the qualifying conditions for a debt relief order, then your duty is to tell the official receiver. At that point, the order will have to be revoked, but you will be given time to come to arrangements to start repaying your creditors again, or come to a reduced payment arrangement. But the debts will not be written off. I repeat, they will not be written off if anything happens within the 1 year that stops the order. It's got to run for the 1 year before the debt can be written off. In some cases, they can extend it, but that is very rare. And if everything's above board, then it should be pretty straight sailing. The official receiver can revoke or amend a debt relief order, but he can't include any debts that have been missed off. So what if my application is refused? If your application is refused, this will be because you did not either meet the criteria, or you didn't supply further information when asked, or the official receiver thinks you've been dishonest in the application. You can appeal this to your nearest bankruptcy court, but you are only likely to succeed if you can prove that you did either meet the criteria, that you cooperated when asked, and you can prove that you were honest in the application. So what if my DRO is revoked? You may need to make arrangements to start repaying your debts again. You can still go bankrupt, but this will cost £680, and you may incur bankruptcy restrictions, which are exactly the same as the debt relief restrictions. You should ask for specialist advice if you think this applies. An individual voluntary arrangement, or IVA, may be suitable for those with large amounts of excess income. I think an IVA, it's at the opposite end of the scale. The time order under the Consumer Credit Act, if you can prove difficulties are only temporary, or an administration order if you owe less than £5,000 and have at least one county court judgment. Details of organisations who can help are on the next slide. And here is where to find help. We've got CAB, we've got the .gov UK website, we've got Refuge for Domestic Abuse Victims, we've got Gamblers Anonymous, and we've got the bankruptcy hearing centres here finally. So thank you for listening to this presentation. If you have any questions, please hit me up in the comments, and thank you. Bye bye.